Hello class, this is Chapter 3, Community Corrections, Diversion and Probation. In this class, we will cover the following learning objectives. We will explain what is meant by the term Community Corrections Act. We will compare the main types of diversion programs and identify their advantages and disadvantages. We will discuss the advantages of being placed on probation, explain the risk assessment models and their current emphasis, describe the various ways probation is administered, clarify the legal rights of probationers, and evaluate the effectiveness of probation and identify some of the promising programs in probation services. Let's talk now about the development of community-based corrections, which can be traced back to English common law. It involves judicial reprieve, which permitted judges to suspend judgment until offenders could seek a pardon or gather new evidence. Then there is recognizance, which permitted offenders to remain free if they promised to pay their debts to the state. And then sureties, where an individual would agree to make themselves responsible for those who had been released. The community corrections revolution began with John Augustus and was formalized in Boston in 1859. This was the formalization of probation. Here's a discussion question for you to consider. New York Knicks point guard Jason Kidd was arrested on July 15, 2012 on suspicion of driving while intoxicated by alcohol after his vehicle struck a telephone pole. He was transported to the hospital for minor injuries, then to police headquarters for processing. He was released on his own recognizance and faces a misdemeanor charge. First of all, do you believe that judges are influenced by the status of celebrities when considering court sanctions? And also consider this: should we hold individuals who make their living in the public's eye more accountable for their actions? The 1960s set the social context for rehabilitation. Diversion is recommended to keep both juveniles and adults out of corrections facilities. This is called the reintegrative philosophy of corrections. The Community Corrections Act, or the CCA, is, as I just mentioned, a state-based act through which counties who participate receive subsidies for diverting minor offenders from state prisons. It is legislatively authorized, and it is a call for decentralized program design and delivery, and provides for citizen involvement. It also requires local planning and provides for state subsidies and endorses locally determined sanctions. Again, it's a reintegrative philosophy of corrections and is, just to remind you, a correctional approach that is aimed at returning offenders to the community as soon as possible. Now we're going to talk about diversion. There is a rationale for diversion, which avoids the harsh impact of incarceration, provides a wide range of alternatives for decision makers, and provides a more justifying justice. And it helps deal with the economic, social, and personal factors associated with crime. There are different diversion programs. There's true diversion. This diversionary program is when the offender has his or her criminal prosecution dropped upon successful completion of this program. There's a minimization of system penetration, and the purpose of this diversion is to minimize the offender's contact with the justice process as much as possible. There is also deferred prosecution. Those referred to these programs benefit from having their charges dropped upon their successful completion. A treatment alternative to street crime, also known as TASC, is a treatment program designed to divert minor drug abusers away from the criminal justice system. And then there are specialized courts, such as drug courts, mental health courts, reentry courts, domestic violence courts, teen courts, and veterans courts. Here's another discussion question for you to consider. The Substance Abuse and Crime Prevention Act, also known as Proposition 36, was passed by 61% of California voters on November 7, 2000. This vote permanently changed state law to allow first and second-time nonviolent simple drug possession offenders the opportunity to receive substance abuse treatment instead of incarceration. First of all, you need to research the proposition's impact and then consider, has Proposition 36 and other similar diversion programs reduced the recidivism rates of drug offenders? Now let's talk about probation. Probation is defined as a form of punishment that permits a convicted offender to remain in the community under the supervision of a probation officer and subject to certain conditions set by the court. It allows the offender to remain in the community under supervision and involves financial restitution, community service, drug or alcohol testing, and also regular employment. Today, there are 4 million people in the United States who are on probation, and although crime rates are declining, the number of people on probation continues to grow. The largest states with concentrations of probationers are Georgia, Texas, California, Ohio, Florida, Michigan, and Pennsylvania. And probation is granted by federal and state court judges. Here's another discussion question for you to consider. It has been reported that about half of all probationers are felons. Many have severe social problems such as drug use and mental illness, and may be HIV positive. Dealing with probationers in an effective manner is a challenge for the correctional system. Now here's the question for you to consider. How do we effectively manage the concern for treatment and rehabilitation in the community versus that of public safety from known repeat offenders? Now there are risk assessment models that come with probation. As far as risk assessment and increased surveillance models, there's a decline in public confidence and backlash against probation, which has led to risk management and avoidance by agencies. And these agencies have also moved away from counseling and interventions to controls. There's an overall changing role of probation, where risk management and increased surveillance models have again moved away from counseling and interventions to controls, and have instead focused more on regulating and controlling offenders than in providing treatment or services for them. Let's talk now about the administration of probation. There are locally administered probation departments where probation is a state responsibility and financial support, setting standards, and arranging training courses is provided. This accounts for nearly 2/3 of all probationers. State or executive administered probation departments are assigned to the executive branch. This provides uniform standards of policymaking, recruitment, training, and personnel management. There are issues with bureaucracy in many probation operations. You have also combined probation and parole departments. Critics of 30 states advocate for separate departments. Proponents suggest that combining the two is a better use of resources. Federal probation involves district judges of the U.S. courts that control federal probation. Then there is the issue of privatizing probation. For instance, Salvation Army's supervisions of misdemeanor probationers programs are one example of privatizing probation. Now we're going to discuss the duties of the probation officer. The basic functions of a probation officer involve casework management and other administrative duties. The file of court documents and chronological listing of contacts with probationers is one aspect of casework management. There is also supervision, investigation, and surveillance of probationers. And this also involves the transition from counseling to enforcement. Then there are pre-sentence investigation reports, which helps the courts decide whether to grant probation at all. Continuing with duties of the probation officers, there are characteristics of effective probation officers. They offer genuine offender-client relationships. They're compassionate and respectful. They have the ability to help others achieve success. They're able to keep their personal problems separate and are motivated and committed to their jobs. As far as the legal rights of probationers, there is the disclosure of PSI reports. Defense attorneys can challenge any disputable statements, and there are some rulings that you need to be familiar with, so please read about them. One is Williams versus New York, which was ruled on in 1949, Gardner versus Florida, ruled on in 1977, and Booth versus Maryland, ruled on in 1987. As far as civil rights for probationers, the U.S. Supreme Court has ruled probationers are entitled to fewer constitutional protections. And those rulings that you need to read about are Minnesota versus Murphy in 1984, Griffin versus Wisconsin in 1987, and the United States versus Knights in 2001. Continuing with legal rights of probationers, there is the revocation of probation that can absolutely take place. This involves a formal hearing with certain procedural due process that is involved. And some cases you need to be familiar with and read about are Mempa versus Ray, 1967, Morrissey versus Brewer, 1973, Gagnon versus Scarpelli in 1973, Bearden versus the state of Georgia, 1983, and the United States versus Granderson in 1994. Now let's talk about the effectiveness of probation. Is probation effective? Recidivism is low for those on probation for a misdemeanor. For felons, however, the majority are rearrested. Women are more likely to receive probation for drug or property offenses. To improve the effectiveness of probation, however, there are more financial resources needed. In other words, when people are released on probation, they often have very little, if any, financial resources to help them get back on their feet and meet the obligations of their probation. Also, there needs to be credibility with the public and the judiciary. In other words, that parolee needs to make sure that they have established credibility with both the public and the judiciary. And as far as improving the effectiveness of probation, there needs to be made a priority in research in terms of the overall effectiveness of probation. There are various probation programs that are available. There is the deferred sentence, which is a sentence that delays conviction on a guilty plea until the sentenced offender has successfully served his or her probation term. There is shock probation and split sentencing. The offender, his or her attorney, or the sentencing judge can submit a motion to suspend the remainder of a sentence after a felon has served a period of time in prison. There is bench or unsupervised probation. In this type of probation, probationers are not subject to supervision. A split sentence is a sentence requiring an offender to spend a period of time in jail before being placed on probation in the community. And then there is intensive supervised probation, where supervision is far stricter than standard probationary supervision. As far as the future of probation services, there should be closer intensive supervision for probationers, closer attention to substance abusers. There should be a screening and classification to guide the level of probation. Closer efficiency and accountability should be demanded for those on probation. There should also be offender fees to help defray the cost of probation. There should also be probation performance indicators to indicate how well a probationer is functioning in the capacity of their probation. There should also be a community probation team approach where there are community counselors and employment counselors, etc. There should also be included probation automated management. And included in that should also be software risk assessment of high-risk probationers such as sex offenders. Class, there's a lot to this chapter, a lot of careful reading that needs to take place as far as your textbook is concerned, and several cases that you need to read about and research on your own. Please remember that this is a tool to supplement your text, not a substitute for the text itself. If you need any help at any time, please make sure to contact your instructor. Thank you so much for your time, and we'll see you next class.